it's an interesting question. They did not in those days regard non-physical acts as searches or seizures for Fourth Amendment purposes. So our modern Fourth Amendment context was not yet theirs. What they were doing was looking at statutory limits on the FCC, which was control of the wires, and wiretapping policy. And in those cases, there are two of them called United States versus Nardone. The court says that the statute does not authorize wiretapping. The statute protects privacy on the wire. And then J. Edgar Hoover says we need to do wiretapping. Jackson says you work for me and you may not. And Hoover goes over Jackson's head and Roosevelt approves wiretapping for limited purposes. That's in 1940. Jackson actually describes this in that manner. And I think Jackson believed there was a serious privacy dimension and that the law protected it and the statutory law protected it and should be followed. In the post-Nuremberg era, I think that sort of privacy, anti-surveillance impulse was all the stronger. If Jackson had lived long enough, I think the evolving Fourth Amendment as a privacy protection would have been something that he was quite comfortable with.
Can you clear something up, please? I thought you said that you needed 5 justices for a habeas corpus petition to be granted. I always thought it was 4 justices for certiorari, and you need 5 to win. Did you misspeak, or did I misunderstand?
They're different things. Certiorari is 4, but a petition seeking Supreme Court review, as a matter of its original jurisdiction, which is what the habeas path was, is a Supreme Court decision. And unless there are 5 votes to hear you, you're not in the door. So as with the Quirin case, etc., that's what was required. So they're just different paths. The way to think about it is that the review in a habeas case is a first decision on the merits. We will hear you. Whereas the certiorari jurisdiction is an appellate path defined by statute, which is we will review you, which is somewhat less substantive. But it takes 5, and there were only 4 until Jackson cast the 5th vote in the row. In the healthcare. Yeah, the question is, will I explain the distinction between activity and inactivity? I'll try. The way the healthcare law was challenged by the National Federation of Independent Businesses in the states and so forth was as a regulation of inactivity. That the government, Congress, had used its power on individuals who had chosen to be uninsured in compelling them to get health insurance, the individual mandate. And that this was a regulation of inactivity, unlike every other act that Congress had ever embarked on, which were regulations of activity. So you're doing something, you must stop, as opposed to you're doing nothing and you must start. And the 4 dissenting justices, Scalia, Thomas, Alito, and Kennedy, in their separate opinion, and Chief Justice Roberts in his separate opinion, together are 5 votes, but are not together, saying that the Commerce Clause does not reach inactivity. The other 4 justices say the Commerce Clause has always reached inactivity. Roscoe Filberman not buying his wheat in the market is inactivity. Congress not giving the favorable tax treatment to a single person is inactivity. That single person has not gotten married. Congress not giving the mortgage interest deduction to the person who doesn't own a home and thus hasn't borrowed money is a regulation of inactivity. You didn't act to take out a mortgage, etc., etc. And really it's just a flip the telescope. Which end are you looking through? And if you read Judge Jeff Sutton's opinion in the Sixth Circuit, Judge Lawrence Silverman's opinion in the D.C. Circuit, Judge Frank Easterbrook's opinions over his whole career, and Justice Ginsburg's dissenting opinion, and every economist in the history of the world, I think that's the better side of the argument. But conceptually, and I think it may just be a one-time event, the court, 5 justices at least, drew a line between activity and inactivity here, said this statute's about inactivity, so the Commerce Power doesn't reach it. As with every Supreme Court opinion, what it means is in the first instance, a question of what it says now, but much more significantly is a question of what later courts will say it means. And I think a couple of parts of the healthcare opinions, if you will, are likely to be unstable because they're not workable. This activity-inactivity distinction is one.
And one of the reasons for lack of citation or proper opinion on that?
Well, I mean, Wicker versus Filbert, if you read it, is an inactivity case, and Justice Ginsburg writes that very directly. No, I just think it's not a black-white line. It's a gray area at the top. Yes, sir. Again, that's just a personal view, and time will tell. And I will watch and kibitz and teach and litigate or whatever with interest, just like all of us.
You indicated in the telegram letter that Jackson sent back there, I think he was disappointed and complaining about. Part of the complaint was about some of the justices that might have full conflicts of interest. Did the court at that time, or any time since, try to draw more rules or act on that? I know recently there's been inaction on that.
Right. The question is about conflicts of interest by Supreme Court justices, and has the court done more since 1946? No, is the answer. Recusal is a matter for each individual justice to decide, as a matter of conscience and when challenged. The judicial code does not bind the U.S. Supreme Court. As a matter of practice, they have said they adhere to it, but it's in the decision-making control of each individual justice. What Jackson was criticizing in Black was Black trying to get the full court to reject a motion that Black should be disqualified. Jackson was just saying, look, this is your call, and you can't hide behind the court. If you think you're fit to judge your former partner's case, you may well be, but you should take responsibility for that decision. It belongs to you. So every justice participating in any case is making his and her own decision by his and her own standards to stay in the case. There's public scrutiny, there's public discussion, there are some things that are fairly obvious. There are recusal issues that lots of justices have, personal investments, family members, prior involvement, in a lower court or in a government position or in private practice. Those are all pretty standard reasons to recuse. But you've already made up your mind about this and you can't be a fair judge. If such a problem ever exists, there's never been a justice who said, you're right, and recused himself or herself from those grounds.
There was a question of accuracy.
Yes, sir.
Yes, the court having drawn this line between activity and do you think that's going to have any major rulings, or is that something walk back?
The question is about activity and inactivity. Do I think it will have implications, or will the court walk back? Sort of building on what I said before, I think more the latter for a bunch of reasons. Big regulatory statutes coming from today's and tomorrow's Congress are not very likely. And big regulatory statutes regulating inactivity, sort of walking into this drafting problem, now know how to navigate better. Phrase it as activity, and put it under the taxing power. So for lots of reasons, I don't think the issue is going to line up very much. If the issue ever does line up, it will depend on who the court is, how it's litigated, and how they choose to sort of add up these 5 votes in the healthcare decision.
Excuse me just a minute. I can notice that Ken Heckler, who was President Truman's administrative assistant, has just come in the church and will be signing books in the back, I'm sure. So avail yourself of that opportunity.
Yes, ma'am.
A quick question. I enjoyed this very much.
Thank you.
That to clarify, Telford's Taylor and Robert Jackson,
Right. Telford Taylor is a huge figure. I'm almost as interested in him as I am in Robert Jackson, but I've only got one life, so I'm keeping my eye on the first project. Telford Taylor was a brilliant young New Deal lawyer, and then a U.S. Army officer and lawyer, and ended up in the War Department in Washington in the spring of 1945 and got put on this Jackson team, which became Nuremberg. And it was a 4-nation international trial. So Taylor's one of the senior assistants to Jackson in the U.S. part of the 4-nation trial. Jackson, in a whole year, finished that, and then Jackson returns to the Supreme Court. The alliance fractures and decides to do no more international trials, but the U.S., because Nuremberg is in the U.S. sector of occupation, continues to prosecute additional cases in Nuremberg. Now they are United States only cases, and Taylor has become the chief prosecutor for those cases. So it's the doctor's case, the judges and lawyers case, the industrialist case, the foreign ministry case. Those are the 12 subsequent trials, 1946 to 1949.
Let's thank John again for a wonderful conversation.
Let me put in a couple of plugs as we close. First, for the rest of the week, tomorrow, my friend Eli Rosenbaum, and again on Thursday, double duty, Eli Rosenbaum. In between, on Wednesday, my friend Howard Trieste will have a conversation with Greg Peterson, which will be spectacular. And on Friday, our major domo and architect, Dr. Doug Neckers, will close this off. And so I encourage you to come back for each of these occasions. I also am happy to talk to you about any of this afterwards. I think copies of Jackson's book, That Man, are available. And if you're not on my Jackson email list and wish to be, it's now somewhere over 20,000 people. And I had to do a server switch because I'm in big trouble with the university. Please just feed me your email address and I will gladly add you. Or just Google Jackson list and the archive will jump up.
And I have one more announcement, and that is I want you to keep this among yourselves. It's totally quiet. We don't tell anybody to talk. But John is going to stay here for a brief interview with Greg Peterson about the Obamacare decision. We'll be taping that immediately after you buy his book.
Thank you all very much.